squatting in Kansas. And the interesting thing about this is I had scheduled this informational hearing several weeks ago. And since then, House, Fed, and State had a squatting bill come before them that they actually passed out of their committee this morning. Are you on Fed and State, Representative Goddard? But you're nodding, so you knew. And I actually have copies of the bill and the balloon amendment that they passed out today. So that might be interesting to you all. First, we're going to hear from Natalie Nelson from KLRD. She did a lot of research on what are the statutes now, and you're just going to tell us kind of about squatting in Kansas. And then we're going to have Jason is sick, unfortunately, so Natalie Scott will be filling in for Jason, giving us a little bit of her side of it from the revisers. And then Ed Klump is going to fill in sort of from the law enforcement side what he's found. I'm happy to pass these out now. I don't know when, it would be most helpful. Natalie, what do you think? Maybe when she starts. Okay, that sounds great. Okay, well then we will welcome Natalie Nelson to the podium, and please give her your attention. Thank you, everybody.
Way down. Hey, good afternoon, committee, Madam Chair. I am happy to talk to you guys today. I think this is my first time this year. Hopefully I won't bore you to tears. And this is some dense property law items. So yes, I'm going to be talking about squatting laws and legislation. So the memorandum that I'll be referencing, you should have either if you get paper copies or it was on the S drive, and I think it should be on the LI as well. So it looks like this. It has the KLRD letterhead. So yeah, this memorandum provides an overview of Kansas law that may apply in cases of unauthorized occupancy of real property, which is commonly known as squatting, and this also includes examples of recently enacted laws and legislation considered in other states addressing the issue of squatting. So the first item of Kansas law that I thought would be relevant to mention is our adverse possession statute, which is found at KSA 6503. And that is the statute that provides that no action may be maintained against a person for the recovery of real property when that person has been in open, exclusive, and continuous possession of the property, either a claim of knowingly adverse or under a belief of ownership for a period of 15 years. So just as a little bit of background sort of on this is a pretty common legal doctrine that's been around for years. And as described in American Jurisprudence, which is a treatise for those that are not attorneys, it's a treatise that provides guidance on various legal doctrines. The concept of adverse possession is sort of based upon the presumption of sort of an ancient or lost grant of title to a person who holds uninterrupted possession of property for a long period of time while exercising control over that property. So it sort of rewards the person who is taking care of property, even when they may not have the legal title to that property. So there's a statutory right, and sometimes there's common law right, but in Kansas we have a statutory right, like I said, in KSA 60-503. So that this presumption recognizes that at the lapse of time, as specified in the statute, so for us 15 years, may cure the failure of the person to properly secure the title of property. So that when, basically at 15 years, if they've been in open, exclusive, continuous possession, then it becomes sort of, they have a legal right to that property. So I included this because I think a lot of times when people speak about squatters' rights, this is sort of one of the concepts that comes into play, because in certain circumstances, you could theoretically have a squatter, someone who doesn't actually have a legal right to the property, but if they meet the statutory elements of adverse possession, they could theoretically, obtain title to that property. In most circumstances, that probably will not be the case, just because, there's a lot of different elements that come into play. But I just wanted to put that out there for you guys.
Hey, Natalie.
Yep.
Is it okay with you if we sort of ask you questions as we go? Because I know you're kind of doing it. So if y'all have any questions about specifically the section that Natalie just talked about, flag me down. Dan will help me look around and see your hands. And so if that's okay with you, we'll kind of do it that way, especially if you all have had people reach out to you asking, or yeah, I know I had, that's why this came about, was that folks are like, what are we doing about squatting in Kansas? Because we've read about it in other places. So if you have questions, let's just kind of let it be a dialogue. I think that will make it easier for you too, Natalie, to do it that way. So yes, Representative Goddard, our first question.
Thank you. Thank you, Madam Chair. Let's take the instance where it's an absentee owner and they live in another state. Haven't been back to Kansas in years and years and years, and somebody is living in a dwelling that they own. I can see all kinds of complications in terms of unpaid property taxes, if that's the case, which would give the county the right to sell that property eventually. But after 15 years, you're saying that the squatter would have legal right to obtaining title for that property?
So, Representative, yes, in terms of, there are specific, so like I said, there's the specific elements that have to be met, and that would come into play when a court is determining whether there is that legal right, if that legal right has been acquired. They'd still have to file for the to be named as that legal owner if that were to come into dispute. But essentially, it's going to be, I shouldn't say that I don't know how often this happens, and that's, I wish that was something that I did have, the information for you all, but it's kind of, it's a very, I would say it's a pretty high bar to meet, because like I said, it can't be like somebody who's secretly, taking up residence. It has to be sort of known to everyone that this person is on this property. They are not letting, anyone else, they're not letting the true owner possess control of the property. And yeah, that's.
And if I may, just one quick follow-up.
Yes, go ahead.
So the 15-year clock, there must be some kind of requirement to show proof of when that 15-year clock started running. So we can say 15 years, but there's no start date to it. I think we know the end date, but there's no start date.
I think that would be something, again, it would be in sort of the petition, the filings when it comes to, quiet title and determining that property. So there would be, basically that clock would start running if there was a claim against the adverse possessor, that, they would be on notice from the time that action that the true owner is trying to say, like, no, this is my property, that would definitely start the clock at that point, that they do not have, first of all, that they don't have permission to be there. So that's one of the, requirements, that the adverse possessor doesn't have permission to be there. And I mean, you could also, provide any other documentation that would sort of prove when you, it's basically to answer your question, it's all something that a court would have to determine, basically, to try or fact.
And could I just add one thing, if you don't mind?
Yeah.
That you said that, it has to be open, exclusive, and continuous, so it has to be open. And so that's kind of, it's open, so someone knows about it, they're not hiding somewhere. So that 15 years starts when it's like obvious that they're actually there. Would you, but again, it's all very specific, and the court would have to decide about that, is what Natalie
Well,
said.
thank you for that. I don't want to drag this out 15 minutes of,
Yeah.
of a committee time.
and
Thank you very much.
Okay, yep. Okay, Dan has a question.
Thank you very much, Madam
I'm
Chair.
sorry. Representative Osmond.
You're all good. So I just wanted to know, so if there's a fee simple absolute in Blackacre, but a fertile octogenarian violates the rule against perpetuities,
Stop it.
Oh, man. I had a feeling this was going to come up, and I was like, I cannot go back there. I can't. It's too much trauma.
Let's move on to
Okay, sorry. Okay, so now we're going to get into landlord-tenant law, unless somebody else has a question.
Representative Martinez, you had a question. Okay.
So is this a process that would happen? Because this happened next door to me. I noticed some people were there, and I pay attention to my neighborhood. And I wasn't real sure that they had just rented it. So I got a hold of the landlord, asked him if he rented it. He said no. And I said, well, there's people in there, and look like they're living in there. So he went and got them and kicked them out. So is this something that is this a process that has to be done, or can they just go say, hey, get out of my house? And they have to get out?
That is actually what I'm going to speak about in the next section.
Okay.
And but yes, there's generally a process, yeah.
Okay.
Okay, great.
Okay, so terminating a rental agreement under landlord-tenant laws. So when a landlord and tenant have entered into a rental agreement involving residential property, the Kansas Residential Landlord and Tenant Act will apply. If this is just sort of the governing statutes here. If property involves a mobile home, the Mobile Home Parks Residential Landlord and Tenant Act applies. And then rental agreements involving non-residential property are governed by KSA 582501 through 582533. So all that to say that termination of rental agreement must be done in compliance with these laws when a valid landlord-tenant relationship exists. However, it's important to note that KSA 58-2573 specifies that the Landlord-Tenant Act does not apply to basically a squatter. I mean, to any person who enters and remains in a dwelling unit without a rental agreement and without the landlord's knowledge, and the person knows that the person's not authorized or privileged to do so, and an order to leave has been personally communicated to that person by the landlord. So the statute further provides that that person can be prosecuted for criminal trespass. So spoiler alert, that we're going to be talking about that later. And a lot of those elements are, again, in that statute for criminal trespass. So in the case of a residential rental agreement, a landlord may terminate a lease for the tenant's material noncompliance with a rental agreement or other obligations that are imposed upon the tenant by applicable housing codes that materially affect health and safety. And the amount of notice that that person has to receive is dependent upon the type of violation. So for a termination for unpaid rent, notice must be given at least 3 business days and plus 2 more days if it's mailed before the lease will terminate, to give the tenant a chance to pay rent to avoid eviction. If the tenant violates another term of the lease that doesn't involve payment of rent, the landlord must give notice of the violation and what is sort of required to remedy that violation. And the tenant has to sort of provide, to prove that they are complying within 14 days of that, and if they do not do that within 14 days, the lease may be terminated 30 days after the original notice of the violation was delivered. And then if a tenant repeats substantially similar violations within the same lease term, then they're not, the landlord's not required to give that 14-day sort of cure period. And they would instead just provide a notice that the lease will terminate in 30 days. So in the case of a tenant who remains in possession of property without the landlord's consent after expiration of the lease, so that's what you may have heard is called a holdover tenant, the landlord may obtain a court order to take possession of the property, but the landlord must do so in accordance with, standard rules of civil procedure. So notice, the petition notice, summons, hearing, all of that. And after hearing and presentation of evidence on the motion, if the judge is satisfied that granting immediate possession of the property is to the landlord is in the interest of justice and will properly protect the interests of all the parties, the judge may order for the immediate restitution of the premises to the landlord. And then one other thing to note is that a landlord may not recover or take possession of the premises by action or by willful diminution of services to the tenant by interrupting or causing the interruption of essential services to the tenant. So that forcible removal may only be accomplished by those authorized to execute a writ of restitution pursuant to eviction proceedings. So that's generally a sheriff or law enforcement officer. So that's sort of the requirements, the protections and safeguards that are afforded to tenants that actually have a landlord-tenant relationship. And so it does not necessarily, if you don't have that protection, or if you are not a true tenant, in a situation that some of those notice periods may not apply. So once we get to, then the next part of that, the next step is eviction. In KSA 61-3801 through 61-3808, those are the statutes that govern the eviction process. And that is to be followed when a tenant has violated the terms of a lease or when evicting any person who does not have a right of possession over the property. So I know I just said that, essentially the eviction process applies even if there's not that relationship of landlord-tenant. The difference is sort of that notice period that's required. And those are the protections that are granted to tenants under the Landlord-Tenant Act. But in terms of actually filing the eviction and sort of executing and actually having the landlord take possession of the premises all follows the same basic process, no matter what, in Kansas. So I broke it out here in the sort of the stages. So notice, as I just mentioned, if a landlord-tenant relationship exists, they must give notice to leave the premises within the time periods specified in that previous section. If no relationship exists and another notice period does not otherwise apply, the notice must be delivered at least 3 days before the eviction petition is filed to give that tenant or that person the chance to sort of pay rent or comply before eviction. Delivery of that notice has to be through personal delivery to the defendant or leaving a copy at the property, or it can be posted in a conspicuous place or delivered by mail, registered or certified mail. So at that point, after the notice, and then there's still, the lease either is still not being complied with, or there is no lease, the landlord must file a petition for eviction with the district court in the county where the property is located. for the eviction. And the landlord may also pay, or may also file a petition for judgment for unpaid rent at the same time. So at that point, the summons, after the eviction suit has been filed, the court will issue an eviction summons for the defendant to appear in court, determined by the court between 3 and 14 days after the day the summons is issued. And that summons has to be served by someone authorized to serve process under Kansas law, so it can't be served by the landlord themselves. Then the answer, the defendant is required to appear in person or by counsel at the time of this, the time and date set forth in the summons, or file a written answer on or before such date. And then if the defendant fails to file the answer or appear in court, then a default judgment is awarded to the landlord in that case. So then if we get to the point of a trial, the trial must be conducted within 14 days of the appearance date stated in the summons, and no continuance can be granted unless the defendant files a bond conditioned for the payment of all damages and rent that may accrue if a judgment is entered against the defendant. And then lastly, we have the execution of the writ. And so if the judgment is entered against the defendant and an eviction is going to happen, the court shall issue, at the request of the landlord, a writ of restitution ordering the tenant to vacate the premises. And that writ must be executed within 14 days of being received by the process server, and the server may use reasonable force if necessary to execute the writ.
Okay, could I stop you
Yes,
for just one
yes.
second? So committee, this is interesting to all of us because we had that eviction bill that we heard about that is actually just going to kind of lay over till next year. It's still in our committee. We didn't work it. And so it's still alive in our committee, and there's probably going to be some tweaks to it. But I hope this kind of helps you understand that bill that they were talking about sealing the records until there's actually a decision. And that's some of the things that Natalie's telling us about right now. So hopefully you will all be here next year, and we will use this knowledge as we look at that bill again after we tweak it some. So, okay, and Representative Osmond.
Thank you, Madam Chair. I have a question regarding after all of this has occurred. So you have an eviction, the tenant is actually moved out, but left property behind. What happens at that point? What is the landlord's obligation to the property that's been left behind, or any notice that needs to be given to the tenant?
It's a good question. I know that there is a statute that speaks to that, but that was not one that I included here, obviously. So I'd have to look that up and get back to you.
Thank you. Okay, prosecution of criminal trespass.
Yes. Okay, so I just spoke about the civil process, and so for eviction. So now I'm going to speak a little bit about the criminal side. So under KSA 215808, the crime of criminal trespassing is in relevant part. It's a pretty long definition, but I just sort of narrowed it here for these purposes. But so it's entering or remaining upon land or a structure when the person knows they are not authorized or privileged to do so, and enters or remains in defiance of an order to leave by the property owner or other authorized person, or the property is locked, fenced, or otherwise secured against passage or entry, or when signage on the property indicates trespassing is not authorized. Criminal trespass is a Class B non-person misdemeanor, punishable for a period up to 6 months in county jail, a fine of up to $1,000 or both, and a probation term of up to 2 years. So for this, I just included some sort of baseline information about, for a prosecution, a law enforcement officer would be, authorized to arrest a person on property when the officer has probable cause to believe that the person is committing or has committed criminal trespass under KSA 22-2401. But then only a county or district attorney may bring charges against a person for criminal trespass pursuant to KSA 22-3201, Or in the case of a violation of a city ordinance prohibiting criminal trespass, a city prosecutor could prosecute pursuant to KSA 124110. So that's sort of just the framework for, just wanted to make sure you knew that there's, a prosecution for a criminal statute is not something that just anyone can bring. It's obviously has to be done so by the county or district attorney. So, and on that note, I wanted to mention that we have some data that I think has been passed around from the KBI that they provided the last, 5 years of 2019 to 2023, the number of criminal trespass arrests statewide, and I think Mr. Bob Stewart is here from KBI who may be able to answer questions about how that data is collected and anything else. I just wanted to mention that before I forget. So,
Representative Barth.
Thank you, Madam Chair. Thanks, Natalie. So a couple things. The clarification and definition for squatter, are we talking about someone that could be there for a very short period of time, all the way to a long period of time would be considered a squatter? Or are they like, no, they're not a squatter if they've only been there for a night?
So thank you for the question, Representative. So we don't currently have a definition of that, of a squatter in statute. And I will say that once I get to the other states, there's differing definitions that states use for squatter. And I think it just depends on, I think what is confusing is when I was mentioning that adverse possession, which requires a long period of time but I don't believe, it doesn't have to be a long period, no.
All right. I do have a comment, actually, if you wouldn't mind. So, and I have a little bit of a personal story to share about a squatter situation as well that pertains to this specific area as well. I do think we need to have a definition of it, and I think it is, from the moment they're there, which could be one day or a night, to any length of time. I mean, if they're not there, they're not supposed to be there, they're not invited. But I was driving to Topeka last year, so on the 2024 stats that are not here, there was a squatter, and I didn't know it was a squatter situation, but I was driving to the Capitol for session last year. It was early in the morning, and there were probably 5 or so sheriff's cars from Douglas County in the yard of the barn that's at one of my neighbors around the corner, and at the time I did not know what was going on. A couple months later, I'm driving home, and it was maybe like at 9:30 at night, so it's dark, and there was a person just walking down the road. And my point of kind of telling this whole story is that we have a lot of behavioral health issue folks, we have a lot of homeless folks, and that they go between different towns in this area, and so they walk down the road, and they are just then saying, okay, I want to go to sleep now, and they went into that guy's barn. So I found out that it was a squatter that was in that guy's barn. That's my neighbor, and he was defiant when asked to leave, and do believe that he did have some background and criminal experience as well, but they had to pull guns on him and stuff to get him to go. I mean, so I do think there is a need for protections. It has happened. And so I just thought it might be good for the committee to understand that too. Thanks.
Yeah, thanks. A good experience. And then, Representative Martinez, maybe we're kind of getting to your question too, that there might be a civil answer and a criminal answer, but that could be for Mr. Klump too, when he gets up here. I think that he could be a good answer to that. Is that okay with you? Yeah. Okay, Representative Carmichael.
Thank you. Ms. Nelson, with respect to the information regarding criminal trespassing arrests by year, I presume this is not limited to those who are trespassing upon rental property, etc. Oftentimes when I think of criminal trespass, that's when the owner of the bar tells me to get out and I don't leave. Does this include that?
Yes, as far as I know, it's not been broken down to any. you know, just squatter situations or, yeah. So it's all of those.
Okay, great. All right, Natalie, continue, please. Thank you.
So now we have arrived to the relevant legislation enacted or considered in other states. I don't think it's probably a good use of time to read all of these to you, but I wanted to highlight a few sort of trends, I guess, maybe in some of the legislation. So in enacted, we have 6 bills that I have listed here. I will say that I'm not going to guarantee that this is every single one that exists at the moment, but it's one of those things that, you know, you put in your search terms and you get what you get. So in Alabama and Florida and Oklahoma, those are all sort of, those laws allow like sort of law enforcement to quickly remove individuals who are occupying a dwelling without authorization. Sort of allows sort of a shortcut for those sheriffs to take immediate action. And then we also have New York and West Virginia. They have defined the term squatter and specified in their statutes that a tenant does not include a squatter, just so that they can keep their landlord-tenant laws sort of separate there. And then there are, I found 19 states that have considered legislation within the last, I think, from 2004 to and this current year. So these are bills these do include those that were introduced and maybe failed because they adjourned, or some of these are still pending because their session has not ended, just like ours has not. And I will let you know that the caveat is that the verbiage I used to search was, squatting specifically. So it's possible there are other bills out there that use different terms, but it seems like, with the amount of search results I got, that is sort of the standard terminology that states are using. So again, there were several states that would, first of all, would create a crime of squatting. So they would criminalize and make a criminal penalty specifically for squatting. And I did not look into those states to see whether, I assume that most, if not all, also have a criminal trespass statute, a crime as well. So there would be a different, specific crime of squatting. And some of these that I was going to highlight, a few of these include the ability of a sheriff to eject or remove or immediately, cause the removal of a squatter when a property owner provides a sworn affidavit of providing, that they are the true property owner, and there's certain conditions that have to be met, records that have to be submitted to that law enforcement officer. But that just sort of so it provides another option aside from the normal eviction process. And same in Connecticut, they would establish a specific process to evict a squatter. And let's see here. Let's see. Nebraska would require a law enforcement officer, when that officer has probable cause to believe a person has committed unlawful squatting, to issue a warning citation advising that the person must provide documentation of authorization to reside on the premises within 3 days of receiving the citation. So that's kind of, when you think about it, it's kind of similar to our current, I guess, eviction in terms of the 3 days notice and then eviction. And then a couple of states have, decided to require an agency or someone to study the issue of squatting and make recommendations to legislature. And I think that's all I wanted to say about all of those state laws. I do have, as you'll notice, they're all linked, so the full text of all of those bills and laws are available to you to look at. And then I did want to mention, in my search, it came up with two bills that were introduced in the U.S. House of Representatives in 2024. HB 7959, which would amend Immigration and Nationality Act to prohibit an immigrant's admission to the United States and to allow an immigrant's deportation from the United States when they have been convicted or admits having committed trespass. And HB 10,009, which would make several findings regarding squatting and would withhold community development block grant funding for jurisdictions that permit squatting. So that is, I think, all I have.
Thank you. Thank you for all of your work.
Yeah.
And that's, I mean, I think especially the states, it's super interesting to hear what other states are doing, and really appreciate that, where we're at in Kansas, and then we'll kind of move on. Now, the U.S., just a quick question, since that was in 2024, we have a new Congress, so I'm assuming they were introduced in 24, but we don't know that anything has actually been enacted.
Yeah, there wasn't anything
Okay.
that
Okay.
moved forward. Yeah.
Okay, questions? Representative Vaughn.
Thank you, Madam Chair. Thank you. So I did take a look at the bill that was proposed or I guess passed out of Fed and State, and it looks like it's along the lines of what you were talking about in terms of authorizing the owner to get a sworn affidavit and to have the law enforcement to remove them because of that. I was just wondering, based on your research, if you know if this is similar to any of the other bills that exist in other states, or maybe that's a better question for Mr. Klump.
Thanks for the question, Representative. I don't recall seeing the exact formatting and the exact, there wasn't any that were identical, but definitely a lot of there were parts of it that were, it kind of felt like an amalgamation of a lot of different state laws that I saw.
That's interesting. Thank you.
Okay, anything else? Okay, Natalie, thank you so much. I'm going to pass these. This is the Fed and State bill. Someone got a little enthusiastic with the stapler, so it's stapled on two sides, so you're going to have to figure that out. Okay, so I will now call on Natalie Scott to tell us a little bit more from the reviser side about what we're talking about.
Sure. Thank you, Madam Chair. And I thought I might start with a follow-up on Representative Osmond's question. KSA 582565 is the statute that outlines that. If you look at subsection D, you'll kind of see the process. But essentially, like 30 days after the landlord takes possession of the premises, they can sell that property or store it at the expense of a tenant. But then there's these notice requirements. So 15 days before you do that, you have to publish it in the newspaper that you're going to do that. And then 7 days after you make that publication, you have to mail that to the tenant's last known address. And then the tenant can come in within that 30-day period and redeem the property if they pay for the landlord's expenses of storing it and selling it. And then the statute also kind of outlines how those proceeds from the sale are supposed to be used.
Thank you very much. I appreciate it. Do you have any thoughts on the rules against perpetuity?
We did that last year, if you'll recall. I had to really brush up on that, watch some YouTube videos of property professors. So I'm going to go over House Bill 2378. Like Chairwoman Humphreys mentioned, this was a bill that was heard and worked in House Federal and State Affairs Committee. The kind of bulk of the substance of the bill starts at section 2, which provides that the owner of a dwelling can request the removal of an unauthorized person from a dwelling by submitting an affidavit to the county sheriff in the county where the dwelling is located that contains the person filing the affidavit is the owner of that dwelling. The person has entered or is remaining unlawfully. The person was not authorized to enter the dwelling. The person's not a tenant or holdover tenant. The person filing the affidavit has requested the unauthorized person to vacate the dwelling, and the person has not done so, and the unauthorized person is not an immediate family member of the property owner. Section 3 provides that when a sheriff receives that affidavit, they have to verify that the affiant is indeed the owner. And after that verification, and at least 24 hours after receipt of the affidavit, the sheriff then shall serve notice on the unauthorized person to vacate immediately. The sheriff is able to arrest any person who's found in the dwelling for any criminal act or any outstanding warrant, and they can charge up to $50 for process of an affidavit under that section. Section 4 provides that the owner shall provide notice at the dwelling, notifying the unauthorized person that they have no right to occupy the dwelling and they have to vacate. That notice has to include the street address of the county sheriff's office where the affidavit is going to be delivered. Section 5 provides liability protection for the county sheriff and political subdivisions for actions that are taken under this new act. Section 6 authorizes a person to bring a civil cause of action for wrongful removal against the owner of a dwelling. A person that's harmed by wrongful removal may have possession of the dwelling restored, and they can also recover damages under that section. And then Section 7 names the act and provides a definition of squatter. House Fed and State this morning did make some amendments, which is what was just distributed to you. Essentially, those amendments expanded the definition of a dwelling to include commercial property and mobile homes. It also added definitions of immediate family member, law enforcement agency, and tenant. It required that the affidavit be notified or notarized. And then that sheriff terminology was changed to use law enforcement agency and law enforcement officer throughout the act. And I can take any questions.
Okay, thank you. Representative Goddard.
Thank you, Madam Chair. I've heard the word dwelling a lot. What about the people that might put up a tent on private property? Now, would they fall under the trespass law, or would they fall under something like this where they could be evicted from a dwelling, so to speak? They own the dwelling, probably, the tent, but they don't own the land upon which it sits.
Sure. Thank you, Madam Chair. The definition of dwelling that's referenced here is in KSA 582543. I don't have that up here, but that is a section that's in the Landlord Tenant Act, so I can't imagine that it would include a tent, because you can't have a rental agreement for something like a tent. But in terms of being on the property, the criminal trespass statute would apply to that, even if it's not a dwelling, because that applies to any kind of property.
Okay, thank you. I think that'd be more appropriate in rural areas where, you'd be out in the woods someplace and come across a tent that's out there and somebody living in it. So thank you.
Okay, any other questions, committee? Representative Barth and then Representative Carmichael. Yep.
All right, thanks, Madam Chair. I just had a question about, and I haven't studied this bill, we just got it or whatever, but you mentioned something about getting a notice. Why are we giving somebody who's there illegally a notice?
Madam Chair, Representative Barth, that would be kind of a policy question that would be up to you. If you look, that notice language starts at page 2, line 17, requiring the owner to provide notice at the dwelling to kind of post something that says, you're not supposed to be here, get out of here. But that's totally, a policy choice, whether you want to require that or not.
Okay, I think that should be obvious. Okay, I have another question too. So does this address, because of the notice that threw me off a little bit, but what about being able to immediately remove that person? Like in the situation I described where my neighbor found somebody, said, you're not supposed to be here. So that's a scary situation. And immediately called, the officials were there. Would this keep the officials from being able to be there immediately and dealing with the situation?
Madam Chair, so I don't think it would prevent, like, if you're referring to calling like law enforcement to come, it certainly wouldn't prevent law enforcement from coming to address the situation. And of course, if there's any like criminal activity going on, that person could be arrested. I think, and obviously Ed's gonna talk to you a little bit about the enforcement, but determining, and it kind of goes back to your notice question, determining whether that person has a lawful right to be there, is not something that can always happen right at the scene, like when a law enforcement officer arrives there. So essentially what this would do is require an affidavit to be filed with the law enforcement agency seeking removal. So there still would be a little bit more of a process there.
Representative Carmichael.
Thank you, Madam Chair. Ms. Scott, I'm not really sure whether, I don't think we're really working this bill since it's
Have to
already
make sure
been
we're
worked.
not working
I'm
the
sorry, I
bill.
couldn't hear you.
I'm
ma'am.
sorry. We have to make sure we're not, the bill's been worked. This is just really questions, maybe not, do we like it, do we not, how would we change it, what would we do, but more questions about the contents of the bill.
Okay, well, my first question about the content of the bill is, at page 1, line 14, it says the intent of this act is to ensure that squatting is considered a crime. But as I look at the rest of the bill, the only crime I find is submitting a false affidavit by the purported owner. Did the committee define a crime somewhere? Did they just say it's a crime but never specify any penalty?
Madam Chair, Representative Carmichael, I would agree with you that that crime that you identified there, that was part of the amendment. If you look, I didn't bring the balloon up here, but, yeah, they just moved that around. It doesn't look like they changed any of the language. So it's providing the false affidavit is a crime, and that's the only crime that's in.
But not the actual squatter. They're not under this bill guilty of any crime.
Correct. Yeah, unless they're guilty of some other crime
Right.
that already exists. Yep.
Then, Madam Chair, my second question about this piece of legislation is at line 11, it says the legislature further finds that squatting or the unauthorized entry into or remaining in a dwelling, and then it goes on to say is a violation of property rights. But I don't see any other thing that purports to be a definition of what squatting is or what a squatter is, and that becomes important because at page 3, lines 1, 2, and 3 says occupancy by a squatter is excluded from the Residential Landlord Tenant Act. Removal of squatter shall not require the use of an eviction action. I'm looking for a good, solid definition of what a squatter is, and I'm not really finding it. All I'm finding is an expression of intent in section 1.
Sure. So the only places that reference that term are in section 1 and then in section 7. There is a definition in section 7. It starts at line 40. Squatter means a person occupying a dwelling who's not entitled to occupy the dwelling. However, the term squatter is not used in the substantive sections 2 through 6. So that reference in subsection C is there, and that's what that definition would be used for, but it's not, that term's not used in the rest of the act.
I had overlooked section 7. I do appreciate that calling that to my attention. I'm concerned about the quality of the committee's work. Thank you.
Representative Vaughn.
Thank you, Madam Chair. I was just going to make a comment. I think on the notice part 2, and correct me if I'm wrong, Natalie, the notice is for them to vacate immediately. So they do receive notice, but they would have to leave immediately. So just making that comment. Thank you.
Okay, are there any other questions? I'm tempted to mention that this went through Fed and State instead of Judiciary, which is okay, but just hold that thought. Okay. Anyone? Well, okay, any other questions for Natalie? Okay, thank you so much. Okay, Ed, if you could come up, and I think maybe they'll have some questions for you after you give us your presentation. So thank you for being here.
Thank you, Madam Chair. Ed Klump, and I'm here today representing the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers. I will add that the amendments that are made to this bill were primarily amendments that we requested, the Sheriff's Association requested in testimony to the Fed and State Committee. And they obviously listened to us and tried to change some things for us. We tried to stay kind of in our lane, and we wanted to talk about the operational aspect of it, but we also saw a lot of the things you've been talking about with, you know, maybe a better definition. They want to say it's a crime, but they didn't make a crime, and there's a fact of you can order them to leave, but there's nothing specific about what happens if they refuse or if they return. So there's several things like that that probably need a judiciary touch on some place. So we'll see how that pans out. So I want to start out talking a little bit about data. I respect the data that the KBI gives you. It is, I'm sure, accurate for what it purports to be, and that is arrests for criminal trespass. I will tell you that probably less than 3%, I would guess, if even that high, of criminal trespass arrests are anything close to what we're talking about. Most criminal trespass, I think Representative Carmichael mentioned this, most criminal trespass cases are you go into some place that you start acting silly and they want you to leave, you refuse to leave, you get charged with criminal trespass. There are other exceptions. For example, you don't have to be asked to leave if you enter into a fenced area. A lot of times when we have prowler calls at night and people are in a fenced-in area, we will charge them with criminal trespass because they climbed over a fence to get in the backyard. And then, of course, the posting signs, things like that. There's various ways to meet the criminal trespass standard. However, I think it's important to note that when we talk about somebody who is in a place and there is not clear violations under any of those other subsections, such as a fenced-in area signage or things like that, law enforcement cannot tell a person you have to leave or I'm going to charge you with criminal trespass. The statute is very clear that the owner or person in charge of the property has to relay that. In fact, if you follow the letter of the law, if a person owns a business and says, I want that person out of my business, the officer really can't go tell that person you got to leave. It's the owner has to convey that message to the person, similar to what this bill does, where the owner of the property has to, by affidavit, declare that, yes, I am the property owner and I do not want this person on my property. So I like to think of this bill as kind of a criminal trespass bill on steroids, and because that's really what we're getting down to. Give you an example. If people go to Walmart and they shoplift, Walmart is going to give them an order not to return to the store, and they'll have that in writing. And if they come back to the store and they catch them, they may call us and we could charge them with trespass because they have been informed by the property owner not to come back in the business. And that is criminal trespass. We don't have to give them an opportunity to leave. But without that order, then we have to give them the opportunity to leave. It's only criminal trespass if they don't leave. So there's a lot of caveats in this that when you get into the practical application, you have to look at. So when we talk about squatting, what people generally think about is the buildings, the structures, but Representative Gard, I think you mentioned the camping. That is frequently in the discussion of squatting where people go on property. However, that's not addressed in this bill because this bill restricts it to dwellings and businesses or commercial property. But it certainly is part of the issue and part of the discussion when we get down to that. I think those are a little more clear cut and easier for law enforcement to deal with through the criminal trespass statutes. But when you have somebody who physically goes into a structure and by all practical appearances, they're living there, they're sleeping there, they're eating there, they're keeping warm there, whatever. Sometimes we can run into situations where that's not a clear, bright line. The worst cases that happen in this, the ones that usually make the media across the country, is real estate property that's vacant because it's up for sale and people will just move into it. I can tell you other cases that we've run into is people die and their house is vacant and their relatives are 4 states away, and they're not in the stage of selling it yet, but it's vacant, and people will go in, they'll go into that house, they'll change the locks, they'll do lots of things. And so by all practical purposes, you go in there and they say, no, I live here, and here, I got the key, I can show you, I can unlock the door and lock it. And so it becomes pretty fuzzy. It becomes fuzzy when it's not the property owner that calls us, it's the neighbor that sees something going on and says, I don't think these people belong there. I talked to the landlord, I talked to the owner in Arizona, and they say nobody should be here. Well, that's good information, but that's not going to be good enough to do a criminal trespass case in most cases. Some states have something in between criminal trespass and burglary. Now, burglary, you have to have the unlawful entry with the intent to commit a theft or a felony or several other crimes inside the structure that you go into. And it doesn't require force. It doesn't require that you break down a door, break a window, knock a hole in the wall or anything like that. But that's burglary. Criminal trespass, on the other hand, is I'm in a place where I've been told not to be. I don't leave, or I come back to that place. And some states will have a law called unlawful forceful entry to a structure, which is you force entry. You're not there with the intent to steal anything. You're not there with the intent to commit any of these felonies. And so it's kind of an in-between crime where you force entry into a secure structure. Kansas does not have that. And so this, I think, becomes an issue in this discussion because that's what we need, is something along those lines. So when we talk about numbers of cases, I suggest you look at, just watch the newspaper. Well, that's no more, there isn't any newspaper anymore. So watch the news and you'll see reports about people's abandoned houses or vacant houses burning. And they didn't have gas, they didn't have electrical, they didn't have anything else. Homeless people have gone inside, they've tried to keep warm in the winter, they start a fire, and they set the house on fire, or maybe it's careless smoking while they're in there sleeping, any number of things. Just 2 nights ago, we had a death in a fire in a house in East Topeka. And it was a boarded up house. They pulled the board off, they went in the house, they were sleeping in the house. House caught on fire, I don't know what the means was, but the person died in the fire. And those are regular occurrences. I mean, I don't know what the numbers are, but I would say house fires are a very regular occurrence in vacant property. And it's usually those kind of things that start it. So there's a lot of things at play. One of the challenges that comes when we encounter one of these is when the person who is in the structure says, no, I have a right to be here, or I have the owner gave me permission. And that's when law enforcement, it's very difficult for us to sort through that. Natalie kind of mentioned that. It's very difficult for us to sort through those kind of things at 3 o'clock in the morning. And so that's when it kind of becomes an issue. A bill like this, if properly written, I think could give us a tool to deal with that. We may not be able to do something right there at 3 o'clock in the morning, but we can contact that property owner the next day and we can verify that they don't belong there and then go through this process and kind of expedite getting that person removed. So I think there's value in this. I think this fills a gap that we have in our laws today. But at some point, the court's going to have to look at some of these cases. And what we don't want as law enforcement is to have this structured so we are being the judge on what legally this person has a right to. Fortunately, most of those people just admit right out front, no, I don't belong here, I'll leave. And that's that. They leave and we're done. They may come back, they may not. They may tell their buddy about it and then their buddy's back the next night. But that's kind of how that works. So we do need kind of a streamlined process. I think the property owners need some kind of a streamlined process to get this started quicker than going through a full-fledged eviction process, which can be lengthy, can be expensive, and difficult to do. So whatever we do to address squatting, we need to be doing it with great caution as far as the authority that we give law enforcement, that we keep, that avenue open, that when there is a dispute of authority to be on the property, that can be resolved through the court. And it needs to be very narrowly tailored. One of the suggestions I heard, which may have merit, is maybe some kind of an ex parte type of order that could be obtained through the court with the presentation of evidence by the owner of the property without the other party being there to at least, we do that on a lot of different things like juveniles and all kinds of things, but that may be something that's kind of getting into the legal aspect that's kind of out of our realm. So that's kind of a quick summary. I'll be glad to answer questions. This is a very challenging area for us. I can tell you in my time as a law enforcement officer, I handled hundreds, if not thousands, of criminal trespass cases. Very few of them were this type of incident. I do think there needs to be clarification in where that line is between a simple criminal trespass and where are you there long enough, or what are the circumstances involved that make this a squatting case that kicks this procedure in. I think there's a lot of good things that many of you have pointed out with your legal experience to look at.
Okay, we'll do questions, and Representative Martinez is first. Thank you.
Thank you, Madam Chair. One more situation. My mother lives alone and she has a lot of land. And I caught a homeless guy coming out of her driveway one day. And apparently he had been waiting for it to get dark and her to go to sleep. And he would jump the fence, set up his tent, and sleep there for at least a month. And she didn't know it because she doesn't look in her backyard. And even if she did, she probably couldn't see because it's dark. So is that just criminal trespass? Because she doesn't have any signs in her yard to no trespass or anything like that.
So it may be and it may not be. If it's a fenced-in area, that's criminal trespassing. If there's no signs and no fence, it can be criminal trespassing, but you're gonna have to go through that process of your mother, for example, would have to say, I don't want that person I don't want you on my property anymore in front of us, and then that person's gonna have to leave or they'd be violating the law. If they leave, there is no violation of criminal trespass statute. If they return and they've been told not to return, they could be cited without the opportunity to leave.
Okay.
And keep in mind, these are misdemeanors. Criminal trespass is a misdemeanor. Many of them are going to be handled by a citation and the person directed to appear in court. And even when they appear in court, even if we take them down and book them into the jail when we have cause to, they're going to be out on the street again in 30 minutes on an OR bond and probably looking for someplace else to go lay their head.
Well, apparently he was pretty well known because when we did call the police, they said, "Oh, well, that's so and so," and he does that. He does that every now and then. But it was scary because he was doing it for quite some time. I caught him coming out of the driveway and kind of knocked him off his bike. But yeah, and I asked him what he was doing there, and he just spilled the beans there.
Another scary scenario that can happen and does happen. You're in your home. Your home's unlocked. Somebody opens the door and walks in. They have no intention to commit a theft. They have no intention to commit a crime. They have no intention to commit a felony. They just walk into your home and babbling because they're drunk or whatever. There's no crime there. That's not even, at most, it's criminal trespass, and that's only if you tell them to leave and they don't leave. And so that's where, this idea of something about forcible entry, but even that's not a forcible entry. So there's just a lot of gaps in between criminal trespass and the other things we can do. So for what that's worth.
Okay, other questions? Representative Carmichael.
Thank you, Madam Chair. Mr. Klump, I very much appreciate your insights. You clearly bring a valuable perspective to the discussion. And I must tell you, we shouldn't make light of the fires that happen. Across the street from my district and Representative Martinez's district, a family ran out in the middle of the night. Unfortunately, only one person was killed, and that was at a house owned by Habitat for Humanity. So it's a big problem. Now, my specific question, Madam Chair, it looks like that the House Federal and State Affairs Committee, in its infinite wisdom, went through and changed references to county sheriff to generally law enforcement agency or a law enforcement agency. Years ago, when I used to have to handle, and I mean used to, it wasn't the happiest duty to do evictions, I can tell you, but when I used to have to do evictions, excuse me, it was the sheriff's deal, okay? The civil court at the county issued the eviction order, the sheriff did the evicting, or sometimes there was a special process server specially appointed to take some action, and that was kind of questionable with the statute. Do municipal law enforcement agencies, are they involved typically in this eviction process? Can you tell us what the chief's attitude is about taking on that responsibility?
Well, first of all, this change was at the request of both associations.
Great.
Because the Sheriff's Association did not present it in their testimony initially, because we hadn't had time to talk to the Chiefs Association about it. And what the Chiefs Association says, no, we want to be involved, because who are they going to call? They're not going to call the sheriff if they live inside the city. They're going to call the police. And we're really not talking about a formal eviction process here. We're really talking about a type of criminal trespass. And many of these cases will be handled as a criminal trespass before even these provisions would kick in.
And probably under a municipal ordinance, I would guess.
More than likely, yeah. Although I don't know whether municipalities would adopt this. We
I
can
don't
apply
know.
this
I
under
agree.
state law. But a criminal trespass would in most jurisdictions be a.
Well, if the chiefs want to do the work, great. I'm all in favor of that.
So that was how that came about, and it was done with thought by both associations.
Okay, any other questions, committee, for Mr. Klump? Okay, thank you. That was super helpful. I appreciate it. Is there anyone else in the audience that would like to just say anything about this situation? Just so you, I know the KBIs here. I don't know if anyone prepared anything else, but okay. All right. Thank you. Okay, committee, thank you for your attention. I hope that was helpful. I think it might have been helpful, because I'm not sure what we'll know more when if this bill, I'm not sure what will happen with it, but we'll see, and we'll know a lot about it. So happy about that. Okay, committee, tomorrow we have 2 bill hearings. I think they're both quite simple. You can take a look at them. I'm sorry, I don't have the numbers right with me. And I also do plan to work House Bill 2348, which is the tenure bill. That's what I'm saying today. I'm not making a huge promise, but just know that that is on the agenda for tomorrow, that we're going to work that 2348. Okay, any questions or anything, committee? For the good of the committee? Okay, we're adjourned. Thank you, everybody.